Good morning, all. My name is Sherry Weber, and I have the honor and privilege of being your Paralegal Association of Florida president for 2023, along with the hardworking executive board of Jody Buck, Patricia DeRamus, David Duell, Valerie Franklin, Asha Maharaj Lucas, and Ricky Whitty. We welcome you to PAF's 2023 annual seminar. May it please the court, how to present an effective case. A view from the bench, insight, if you will, was our goal for this year's program. I believe we have been able to achieve that with our honorable lineup of speakers coming your way. Should you need anything during the seminar, please email me directly at president@pafinc.org. At this time, we would like to thank and recognize our platinum sponsor, Trial Consulting Services, particularly Russ Willis, for pulling all this together on one platform. Each year, from the first 50 people to register for seminar, one lucky person is picked at random to receive the next seminar's registration fees waived. This year's lucky winner is Rebecca Gaskin. We look forward to seeing you at the next seminar, Rebecca. Now on to awards. One of the best parts is to be able to acknowledge and recognize outstanding leadership and commitment to our profession, the legal community, and PAF as a whole. And with that, I am truly honored to announce that Christian Rimling of the Treasure Coast chapter has been awarded this year's Paraleader of the Year award. Kristen has been a member and president of the Treasure Coast chapter for many years. She is a true leader by example. She promotes and gets members involved with community service projects throughout the year. Her leadership helps create a more equitable and informed society when it comes to legal and community matters. She makes herself available to assist and counsel whenever called upon. I know this firsthand. After careful consideration, the executive board has decided there will be co-winners of the Up-and-Comer Award. Therefore, I am pleased to announce that Shannon Hines of the Palm Beach County chapter and Jamie Hirsch of the Broward County chapter are both recipients this year of the Up-and-Comer Award, as both are showing great involvement in their communities, chapters, and PAF as a whole. As for anyone who is not a member of PAF or knows someone who may be interested, the First Coast chapter is currently holding a membership drive, which waives the application fee until November 19th. If submitting an application during the drive, you are able to pick any PAF chapter to be associated with or be a member at large. If you need more information, please reach out to anyone, and we will be glad to direct you in the right person. At this time, make sure you have yourself settled in and join us now as we have a chapter spotlight before our first speaker. Thank you.
Hello, I'm Ricky Whitty. I'm the state parliamentarian, and I have the pleasure of introducing the Honorable Jack B. Tuter. Judge Tuter is currently serving in his 6th year as Chief Judge of the 17th Judicial Circuit, which is Broward County. Judge Tuter is currently assigned to the Complex Business Litigation Division of the circuit. In the past, he has also served as Administrative Judge of the Civil and Unified Family Divisions of the court. He has served on the Complex Tort Division, General Civil Division, and the Family Division of the court. Prior to judicial service, Judge Tuter served as Director of the Alcoholic Beverages and Tobacco Division of the state of Florida. Prior to public service, he served as a managing partner in a civil trial practice. The tort reform signed into law this year will have a major impact on the practice of law, on civil litigation, and on the court system. Judge Tuter will talk to us about the impact on the court system. Judge Tuter has on several occasions graciously spoken to the Broward chapter, so I know you're going to enjoy his presentation.
All right, good morning, everyone. My name is Jack Tuter. I'm the Chief Judge in the 17th Judicial Circuit, and I appreciate the invitation to speak to you all today. Our audience today is the Paralegal Association Fall 2023 meeting, and I'm going to discuss with you some of the legislative changes that have taken place. So I want to talk a little bit about a couple of items today. One is primarily discussing the 2023 Florida legislature changes to the Tort Reform Act, as they called it, and how it affected our circuit. And I think you can extrapolate, those of you who aren't in the 17th Judicial Circuit or work in the 17th Judicial Circuit, which is Broward County, how it might have affected the circuit that you may be working in. So from February 13th to March 24th, before the new statutes went into effect, there were 10,296 new circuit civil cases filed in the 17th Judicial Circuit. That's 10,000 new cases in addition to the cases we already regularly handled. In county civil, the impact was 18,508 cases. Most of the county civil cases break down into two areas. One would be insurance cases, PIP cases, and the other just regular insurance losses. Since their jurisdiction has increased, the civil county cases month to month have definitely seen an impact. So the total impact in the 17th was, in 1 month, we absorbed 28,804 cases, a substantial impact really for any particular circuit, but one where we have large numbers of judges. Here in the 17th, we have 90 judges, and therefore the impact was a little bit less impactful, because we have 16 circuit court judges able to handle the circuit civil cases, and we have about 8 or 9 county civil judges, so 25 judges absorbed this impact. Okay, so we met with the ABOTA attorneys after all of this, these new cases were filed, and the ABOTA attorneys filed a bunch of questions with us and asked us to discuss the questions and various topics. And again, you've got to understand the impact. This was in April of this year. So some of this has come to pass, and I'll tell you what we did to handle these cases here in the 17th. But one of the questions posed by ABOTA to see if they could help with this influx of 28,000 new cases was whether retired attorneys could serve as temporary law clerks or serve in case management roles for the next 6 to 12 months to help with the administration of sudden increase in case volumes. Would such volunteers be welcomed by the court? Well, of course, we'd be welcome anybody who could come and help us here in the court system. But there were a number of impediments to this, so to speak. One is the computer system that we operate here with state government. We are always a little bit apprehensive to give anyone who is not a full-time state employee access to our court system. For those of you who don't know, we get the court system in general, from Pensacola down to Key West, gets thousands and thousands of attempts to break into our computer system every week. It is cybersecurity is a really big deal. We just recently got an email from someone saying one of the circuits was hijacked. I don't know if they paid a ransom or how they got out of their situation, but cybersecurity is a big deal, and thus giving access to people who aren't state employees to upload information, participate in the email system. It's just something that we always have to be cautious of, especially as chief judges, to make sure that passwords and information that's internal to the system does not get out. It's not so much that the information gets out, it's that persons could answer emails or other things that would lend the system to vulnerability. And so for everybody who works in state courts, we didn't think this was a very good idea. So the next question is, can the courts consider promoting the use of arbitrators under Florida rules to handle discovery disputes to try to ease the burden on the courts? Again, another very good idea, not one that we actually considered or implemented. Arbiters have their own duties and responsibilities under the rules. We would probably, if we were to do that, would have to do it somehow by administrative order as a chief judge. And the chief judge has only so much power. The chief judge cannot affect or overrule or kind of do things that would violate the rules of civil procedure, or even change the rule of civil procedure by administrative order. So we chose not to do that. There is a committee that reviews administrative orders that are entered by chief judges, and we're always, as chief judges, leery about using things that might violate a statute or a rule of civil procedure. And so we're very cautious about these kinds of things. Can the chief judges throughout the state request the Supreme Court provide more discretion to trial judges when considering motions for continuances? Okay, well, that's a big one. The lawyers are always want continuances, and the judges are always wanting to resist. So you'll kind of have this mashing of teeth when these motions are filed. The Supreme Court, as you all know now, has given the trial courts and the chief judges specifically the marching orders of moving cases through the system in a more timely manner, in a more efficient way, using case management conferences, etc. So when continuances are filed, unlike the old days, they are generally looked at with a degree of scrutiny. How long has a case been pending? How active has the case been? Why haven't the lawyers been moving the case? There's lots of things that the judges look at when granting these continuances these days. And cases that are really in the system in general civil, more than 2 years, are going to be looked at with great scrutiny as far as granting continuances. The things we still grant continuances on are illnesses of a party or the attorney involved in the case, emergency matters that no one could expect, and those kinds of things. But for the most part, I would say the trial courts these days, especially in circuit civil, look with a great deal of skepticism in granting motions for continuances. And the 17th Circuit take immediate measures to address ethical and practical issues in setting motion calendars. So no matter where you are in the state, this issue has been around. I've been in the civil division now between a judge and a lawyer 40 years, and nothing's changed really in 40 years, to be honest with you. There are some lawyers who are very good at being ethically and practically appropriate during motion calendar. In other words, they do try to settle the motion calendar issues the day before. They do speak to their opponent. They do try to narrow the issues prior to bringing the issue before the judge. Same thing with special set hearings. Special set are a little bit different because you're occupying the judge's time on their docket. And if you do settle a matter and you don't tell the judge, most of our judges are very efficient these days. They read whatever is pending. And when you have a 15-minute or a 30-minute or even an hour special set, you don't advise the court the motion is reset or the motion is canceled or the motion is settled. It's a big deal for the judge. It's also a big deal for the other lawyers who practice in front of that judge who's looking for time to set a special set hearing that possibly could have been plugged into that slot by the lawyers just not canceling online and not contacting the other side and trying to discuss the issues that are going to be before the court. Petty little matters, not agreeing to a short period of time to answer discovery. Those kinds of things just kind of anger the judges because we have so many things to do, and it's just basically two lawyers not communicating with each other on a matter that should have been resolved out of court. The lawyers have to just be more professional towards each other and quit being childlike with setting motions before a judge that really they should have settled out of court. And when you get an influx of 28,000 new cases, it's a big deal on the special set calendars more than anywhere else. Because that means all those new cases are gonna be in the system, and all those lawyers on those new cases are gonna be requesting special set time, which could push those dockets back weeks or months. Okay. On a short-term basis, the number of new cases has the potential overwhelm. That's what I just said, case management system self-scheduling. Here in the 17th, and I think mostly throughout the state now, everybody self-schedules motion calendar and also self-schedules special set hearings. In the 17th, we allow them to special set 15 or 30-minute hearings on their own. And if they need more time than that, then they generally have to write the judge. The JA will give them permission and tell them to self-schedule the time if it's an hour or less, or if it's more than that, the JA will schedule it for the lawyers. And as I just said, new cases had the potential to overwhelm the system. So far in the 17th, that has not occurred. We absorbed all of the cases. We did not make any substantial changes, but I will kind of comment on some of the things that occurred throughout the state that I'm aware of. Well, the crisis on motion calendar or special sets, we didn't have a crisis. What are short-term solutions? We didn't have to remote to short-term solutions because we absorbed the cases and saw no substantial increase in the dockets. All right, they also ask if ordering the ability to self-schedule if text emails are not returned within 48 hours. Okay, so all of this slide deals with special set hearings, and I know all of you all, paralegals, those of you who do set hearings for the lawyers, this is a big deal. Special sets more so than anything. Most motion calendars during the week are open enough to get on for short hearings. So we do motion calendars here 4 days a week, 8:45 to 9:30, and you can pretty much get on 5 days notice on anything that's 5 minutes or less. So when it comes to special sets, the problem really exists is one side wants to set a hearing and the other side either wants to delay setting the hearing, ignore the request to set the hearing, or just is not being very ethical or professional. I adopted a rule. I handle complex business cases here in the 17th. I adopted a rule that said that if you do not contact the other side within 48 hours after they have contacted you to set a special set hearing, 15 minutes, 30 minutes, whatever it is, if you do not contact them back, you can self-schedule it yourself. In other words, you don't need their permission to pick the time and date. If they were the ones that caused the delay, then getting it self-scheduled will get their attention. They asked if we could do this circuit-wide. Look, I have only so much discretion as chief judge with the judges. They're all elected officials, and they all have the preference of setting their schedules and dockets the way they want. So we haven't come to that yet. As you can see from this slide, 46% of all of our special set hearings cancel 3 days in advance. That's a big deal. Again, back to my theme that if these hearings are canceled through CMS, it gives other parties an opportunity to put a hearing that they're looking to advance on the docket into those slots. Listen, some of the judges complain that they reach agreements on these special sets. I'm sure not one of those that disagrees with that or agrees with that. Getting cases on a docket and getting the attorneys to agree to resolutions of their matters is just a beneficiary to the civil justice system. Okay, so now I want to talk to you all a little bit about the tort reform and the things that were advanced in the 2023 session of the legislature. And these are in no particular order, but I'm going to give you an overview here. The bill that was passed on March 23rd, the following is a summary of the most significant components of the bill. Attorney's fees, comparative negligence, transparency and damages, duty of good faith, contingency fee multipliers, statute of limitations, and premises liability issues. So these are the things that the legislature dealt with that were most prominent during the session. And I want to go over some of these with you all I know by this time that you're seeing this presentation, many of you have already dealt with these changes. So I'm going to give you kind of an overview of what my thought on some of these things are, and you all have your own thoughts. So let's move to the next slide. All right, attorney's fees. We've got some things here. So they changed the attorney's fee statute. 627 480T was repealed or deleted, and the offer of judgment statute now applies in all civil actions. The next slide, one thing, those of you who do construction cases, the construction surety insurers retains an independent right to fees for the plaintiff. In other words, if the surety is suing to one of the contractors or subcontractors for damages they had to pay, they now can claim a right to attorney's fees. Surplus lines was repealed. Wet marine transportation insurance and title insurance was also changed. Credit life and credit disability, international health insurers, and commercial self-insurers. And I'm going to go through some of these in more detail. Those are just kind of an overview. So one of the things they changed was multipliers. 571052 is new now. 571052 is computation of attorney's fees. Let's see if I've got a slide on that. Okay, so the one of the things that I know you all may have seen of interest to paralegals for sure is computation of attorney's fees in cases. In any action which attorney's fees are determined or awarded by the court shall consider, among other things, time and labor of any legal assistants who contributed non-clerical, meaningful legal support in the matters involved and who are working under the supervision of attorney. For purposes of this section, legal assistant means a person who, under the supervision and direction of a licensed attorney, engages in legal research, case development planning in relation to modifications or initial proceedings, services, processes, applications, or prepares or interprets legal documents, etc. In any action which attorney's fees are determined or awarded by the court, they also found there is a strong presumption that a lodestar fee is sufficient and reasonable. This presumption may be overcome only in rare and exceptional circumstances with evidence that competent counsel could not otherwise be retained. Many of you know on lodestar, prior to the enactment of the statute, in lodestar cases, the trial judge had the discretion to apply a multiplier depending on the degree of difficulty of the case, whether the plaintiffs could obtain competent counsel, the work by competent counsel. So in addition to just awarding that attorney's fees, the judge could do a multiplier 2, 3, 4 times in some cases. And so that was an issue that was under great scrutiny at the legislature this session, and they changed the law basically to say now there's a presumption against it, that it only would occur in rare cases where at this point it is going to be looked at with great scrutiny, whereas in the prior file cases that are still in the system, I suppose an argument could be made that you would be entitled to a multiplier on lodestar cases, but I think that's going to be under strict review by the appellate courts. Okay, so they also had another issue in these statutes, which I suppose all of you are grappling with or will be grappling with, is the retroactivity application of the statute. And the legislature wrote, this is an act not to be construed to impair any right under an insurance contract in effect on or before the effective date of this act, which again was March 23rd, 2023. To the extent that this act affects a right under an insurance contract, this act applies to an insurance contract issued or renewed after the effective date. There has already been a degree of scrutiny of some of these legislative changes. Although not in the civil context, a number of judges throughout the state, including many of our judges, on the death penalty changes that were made. They are now using the 8-4 instead of unanimous death penalty numbers when a jury is considering a death penalty case. So that's going to be under some scrutiny. We also had a judge, I wish I had the case in front of me, I would give you the judge's name, a circuit court judge somewhere in the state, wrote a long-winded, I mean, it was very thorough opinion that opinionated that the changes that the legislature made are not necessarily retroactive. In other words, they're prospective. And so that's something that everybody is going to grapple with in trying to interpret certain cases and whether the new laws apply to the cases that are now in the system or only the cases that were filed after March 23rd. Okay, the legislature also dealt with something that was a big deal for many members of the legislature, and that was bad faith. And so they amended 624-155. As many of you may know, bad faith kind of comes in situations where you have a horrific accident and the insurance company or the self-insured defendant, so to speak, knows there's a terrible event, and despite that, does not tender the policy limits. The most, I guess the easiest example would be you have an accident with a bus and 10 people are killed, and the insurance company does not handle that case, so to speak, in good faith, and instead investigates, and doesn't settle the case prior to the lawsuit, or engages in what the lawyers would refer to as bad faith by settling with maybe one person and leaving the other 8 out, etc. So it was a quandary that the insurance companies faced in dealing with these kind of tragic, horrific accidents where there's low limits and significant damages. So the civil remedy statute here, the civil remedy creates a safe harbor within which the insurer may correct alleged so-called bad faith acts by attempting to settle a claim in good faith. Thus, the insurer is not liable for bad faith regarding a liability insurance claim. So what's the result if the insurance company is found to be in bad faith? Well, they all of a sudden become the full insurer for the losses. So if you have a $10,000 limit in an automobile crash and the insurer is found to be in bad faith and they're awarded $1 million, the insurance company is on the hook for $1 million, even though they insured for only $10,000. So here, the insurer is not liable for bad faith regarding a liability insurance claim, whether brought by statute or common law, if the insurer, 1, tenders the lesser of the policy limits, or tenders the amount demanded by the claimant within 120 days after receipt of actual notice of the claim. And furthermore, in the event that there is failure by the insurer to tender within 120 days, it is not considered bad faith and inadmissible in a bad faith action. Moreover, if failure to tender within 120 days, the applicable statute of limitations shall be extended for an additional 120 days. And this is applicable to all so-called bad faith claims. So I did some of these when I was a practicing lawyer on the defense side. And normally what would happen would be the plaintiff's lawyer would get creative, knowing that he has catastrophic damages, but only low limits. And he may not even let the insurer know that he's representing the person until a few days before they file suit. They don't tender the limits, and then they sue the insurer for bad faith. So you can see from the statute the way the legislature wrote it. They don't like bad faith, and they're doing everything they can to protect the insurance company. This is not to say that all of the insurance companies and self-insured companies are dealing in good faith. Some of them just hold the money, and don't try to effectively negotiate the claim in good faith. So it cuts both ways, but you can see from the statute, and I think the case law going forward in the appellate court and probably the Supreme Court will be favorable to the insurance companies in bad faith cases. So let me click to the next slide and discuss some of this. Mere negligence in and of itself does not constitute bad faith. The insured or third-party claimant or representative for the same has a duty to act in good faith in furnishing information, and the trier of fact may consider whether the insured or third-party claimant or representative for the same failed to act in good faith and as such reasonably reduce their damages accordingly against the insurer. That's going to be an interesting way the trial judges handle that and the way they craft jury instructions. All right, so I'm going to skip forward to the next topic. All right, this is another big one you all are aware of. So this is the meaning of 9511. So it changes primarily section 4. I have some of that for you. Section 4 now reduces most, if not all, negligence cases to 2 years. The statute goes from 4 years to 2 years. The statute specifically says 2 years on actions founded on negligence, on actions founded on professional malpractice. That was always the same. It also amended the statute to say an action for medical malpractice shall be commenced within 2 years from the time of the incident giving rise to the action occurred, or within 2 years from the time the incident is discovered. And it goes on to give some disqualifiers. Also, now changed, an action to recover wages or overtime damages or penalties concerning payment of wages. Wrongful death did not change. That's been 2 years. An action founded on violation of 517. Sorry, I don't know what that one is. An action for personal injury caused by contact with exposure to phenoxy herbicides while serving as a civilian or member of the armed forces. That's going to be a big one. An action for libel and slander. All of those have changed now. And if those are not, actions are not filed within 2 years of the action, and again, most are interpreting that to mean after March 23rd, 2023, they're going to be 2 years statute. And that can be a quandary for a lot of lawyers who are used to dealing with 4-year statutes of limitations. You can no longer just investigate these cases to death. You're going to have to file within 2 years or run the chance that your case is going to be dismissed. Next, comparative fault, another big one. We've gone from being a pure comparative negligence state to a modified comparative negligence state, meaning if the tortfeasor in the case is found more than 50% at fault, he may not recover any damages. It would be complete bar to them recovering. Now, I will say on this, and let me look to the next slide. No, let me just stick on that slide. I will say as a judge over the years, I tried a bunch of tobacco cases when I was in complex tort. There, from time to time, they would find the smoker significantly at fault for their smoking, but they would also award substantial damages. So here, this would be a complete bar if they were more than 50% at fault. And I would say in all the years I've tried general negligence, it does not happen that often. It seems to me the lawyers are smart enough to figure out, especially the plaintiff's lawyers, if they've got a case where their client can be found more than 50% at fault, that they resolve those cases out of court. There has not been, in my experience as a trial judge, a significant amount of plaintiffs found more than 50% at fault. So this is a big deal out of court. I'm not so sure it's going to be a big deal in court with the cases that are being, the negligence cases that are being tried. Legislature also changed admissibility of evidence to prove medical expenses, another big deal in personal injury cases. Disclosure of letters of protection, another big deal. Recovery of past and future medical expense damages. provides for a uniform standard in calculating the accurate value of medical damages. So what happens in court? The plaintiff has $1 million in medical expenses. Some of them, the doctors took letters of protection on. Some of them were paid by either Medicare, Medicaid, private insurance, whatever it was. So let's say, for instance, they paid $500,000 of their $1 million. Well, the plaintiff's lawyer wants to show the jury how significantly injured their client was by introducing the $1 million in medical expenses. And the law has changed on that. So now it provides guidance, the statute does, on what evidence is admissible to be presented to the fact finder to prove the amount of damages. Past paid medical bills, big deal. Restricts evidence of services that have been satisfied to the actual amount paid for services. Thus, the amount paid by the insurer is only the amount admissible, regardless of what was initially billed. So if the provider bills $2,000 for a service, but then reduces the bill for whatever reason, insurance or otherwise, that's all the plaintiff can board. They cannot board the total amount of the bill. Past unpaid medical expenses. The bill shows as admissible any evidence to prove damages that is otherwise admissible, and provides that usual and customary amount of damages is dependent on whether the claimant has insurance pursuant to delineated specifications. Not admissible as evidence are contracts between providers and authorized commercial insurers or authorized health maintenance organizations, as such are not subject to discovery or disclosure and are not admissible. So this provides a uniform guidance for evidence to prove damages in future medical treatments, and also provides the usual and customary amount of damages. Next, another big deal in all these cases are these letters of protection that the doctor takes to provide treatment, and then says, you'll pay me if the jury awards you damages. So there's been some discussion statewide whether the copy of the letter of protection can be admitted or discovered, and now the legislature has solved that. All billings for the medical expenses to be itemized and coded according to standards as stipulated. You can also introduce whether the claimant had health coverage at the time of the treatment. If the claimant was referred to a treatment under letter of protection, the identity of the person who made the referral. So if claimant's attorney is the party who made the referral, such evidence is allowed, notwithstanding lawyer-client relationships. That's how a lot of this was being kept out by the plaintiff's lawyers. Now, if they're making the referral, the jury gets to know about it. It also prohibits inflated amounts of damages in excess of the evidence that may be admitted under the bill, and thus prohibiting an award of damages from exceeding actual amount of the bill paid, amount of necessary to satisfy outstanding medical services, and the amount necessary to provide for reasonable and necessary future medical expenses. This statute's a big deal in the courtroom. These kinds of things happen all the time, and this statute has definitely changed the game on the admission of medical expenses. Another big deal, I used to represent a lot of hotels, 7680701, notwithstanding 76881-4 in an action for damages on premises liability, where a person is lawfully on the property and injured by criminal acts of third parties, the trier of fact must consider the fault of all persons who contributed to the injury. What's that mean? You're at a hotel, you're at a Marriott, you're in the parking lot, you get assaulted, someone robs you. In the current state of the law, because that was an intentional tort, the intentional tortfeasor is not on the verdict form. Jury doesn't even get to consider their degree of so-called fault because it was an intentional act. Now you get to consider the fault, the fact finder, the jury gets to decide the percentage of fault for the wrongdoer. So if the criminal is found, 90% at fault for pointing the gun at the plaintiff and scaring the plaintiff and robbing the plaintiff or assaulting the plaintiff, that is something the fact finder now can consider. Prior to the enactment of this bill, they were not allowed to consider the wrongdoer's fault. This is going to be a big deal on premises liability cases where there is criminal acts. All right, I'm going to skip over some of this. You can read it on your own relating to that on premises liability. So to recap, the new law provides a rebuttable presumption that a lodestar amount is reasonable only to be overcome in rare circumstances. The reduction of the statute of limitations for negligence actions, standards for bad faith, standards for distribution of proceeds when two or more third-party complaints, third-party claims arise out of a single occurrence, such as the bus accident we're talking about, limitations as to the applicability of provisions relating to attorney's fees in certain actions against insurers. So that is the highlight of the statute. It also went through standards of evidence to prove in medical expenses, the requirement of the trier fact to consider fault of certain persons who contribute to an injury we just talked about, and revisions relating to immunity stemming from liability for injuries to trespassers. All of those things were encompassed in the statute, and I'm going to leave you with one last thing, and that is a case that came out of our circuit. Punitive damages remain a big deal for trial judges. I call your attention to read this case. It's called Federal Insurance versus Perlmutter. It's got a really interesting set of facts, and I'm just going to highlight them for you and in the presentation. This was a guy who was a tennis instructor at some condo or homeowners association. That's not important, but for some reason, things went awry at with the tennis instructor, and someone at the association sent a series of emails and letters, written letters, saying that he was a child molester. So he filed a lawsuit against the association and tried to figure out who was sending these emails. Somehow, some way, I'm not going to go into detail because the case is rather lengthy, he surreptitiously, as the court stated, he surreptitiously obtained the DNA from certain persons who lived at the association, who he was suspicious were sending out these letters calling him a child molester. Lo and behold, somehow the DNA came back and implicated a couple of people. I think he got the DNA off maybe the letters that these people were sending. And they implicated a couple of people who lived at the association. So these two people at the association turned around and counterclaimed, saying that he violated a statute that made it a misdemeanor to obtain people's DNA and use it in a so-called public or private way. And there's a statute that says the DNA is the exclusive property of the person tested. So lo and behold, both sides sued for punitive damages based on this peculiar set of facts. The fourth district said, and I'm going to just give you the conclusion and why I think they came to this conclusion. The fourth district ultimately determined that the person who had their DNA surreptitiously obtained, so-called illegally in violation of a Florida statute, did not make a case for punitive damages, even though the trial judge agreed that the statute was violated and that their personal privacy was violated by obtaining their DNA in this way. The fourth district, I think, if you read the opinion closely, basically said, well, yeah, it was a violation of their privacy, but he didn't try to get their DNA to violate their privacy. He tried to get the DNA to establish his case that they were the perpetrators of sending these letters that claimed he was a child molester. So the fourth district went through in great detail punitive damages, what it takes to obtain punitive damages, the clear and convincing standard, and more importantly, whether the threshold of reprehensible or outrageous conduct is met in the proffer that the plaintiff makes in these cases. And I would say to you, if this is not a case of punitive damages based on the facts of the case, there aren't going to be too many that are going to lend an ear to a fourth district or a district court of appeal that's going to favorably see the issue of punitive damages. Our circuit here, fourth district circuit, has over and over kind of held that punitive damages are reserved for the most egregious of civil actions, the most god-awful set of facts, not just that somebody did something bad, something egregious, but it is to be applied in the most rare of cases. And that's kind of the threshold that I go by. I don't get a lot of assertions for punitive damages in business cases, but in tobacco cases, punitive damages were pretty much a foregone conclusion based on the past history of the tobacco companies. But nowadays, I think the Supreme Court and the DCAs are looking at punitive damages in civil cases in a much more rare of circumstances type standard. So when you're either making the proffer or trying to defeat the proffer, I point you to this case and look at some of the DCA opinions on this topic, which are coming out.